Good afternoon, everybody. Welcome to all the OPG membership. It's 1 o'clock and we're about to get started. I'm hearing some echo on somebody's end, just in case they have more than one thing open. Check that. But we're going to let everybody filter in for about 2 minutes, and then we'll come back online and get things started, just so we don't make people miss the beginning of the webinar. So just hang out for 2 minutes, and we'll come back from them. Thanks. All right, we got everybody filtered in pretty quickly. We've got a good crowd coming. So just a couple of house cleaning items before we get started. I have up on screen, which hopefully everybody can see, is our link and our QR code to our October dinner conference. If you haven't registered, please do so. I'd like to get a nice big group and get everybody together. We took a couple of year hiatus with COVID, so it'll be great. Joel Press will be there, stirring the pot and having some great conversations. So I look forward to everybody joining that. We've got a couple of other things. We have an open survey on carried interest vesting. One question, 30 seconds if you get a chance to do that. That would be terrific. Okay, so I'm going to stop sharing my screen, right? Share my webcam, which hopefully everybody now can see. There I am. Can everybody see me? All right, excellent. So let's change the audience view. I apologize, bear with me. Interesting. All right. Not what is normally the case there. I apologize. Anyway, okay. Well, visuals aside. Michelle and Beth, you can hear me?
Yes.
All right, great. So I want to take a moment to introduce Michelle Gibbs Eitry, and we've also got, I hope you can see this on screen, Beth Smigel, both partners in the investment management section for Tannenbaum Helpern. I actually met both of them in face-to-face a few weeks back or a few months back at a luncheon that they put on with some great discussions and topics. So I asked them to get together with OPG and all of our hedge fund peers to talk about some current issues, which they've been kind enough to do. So I'm gonna throw it over to you guys to talk about some of the great topics I know that we've discussed. And also I will add that anybody who has a question or wants to make a comment, you can use the chat and or question box for the webinar. We probably won't stick it in the middle real time, but maybe at the end we'll cover anybody that sent something in, and if we don't get to it, then I'll also pass that along to Michelle and Beth that they can cover after the webinar. So I throw it to you guys and take it away.
Great. Can you hear me?
Yes.
Okay, great. So thanks for having us. There's certainly been a lot of recent SEC activity, so we are looking forward to this discussion. I'm Beth Smigel. I'm going to start with some general guidance and sort of new requirements under the marketing rule, specifically as it relates to presentation of performance and track records. So I will tackle that first, keeping in mind that in certain respects, the SEC adopted this new marketing rule, specifically the performance requirements, to incorporate a patchwork of no action letter guidance that registered investment advisors had previously been relying on. But in doing so, they created a number of pain points for registered investment advisors. So the first category of performance is performance requirements are net performance, which has always been required for presenting the portfolio performance as a whole, but has been extended by the SEC under the new rule for presentations of extracted performance, which is defined by the SEC as a subset of investments. While there was some hope within the industry that it wouldn't necessarily apply in every situation, including with respect to case studies and presenting performance for individual investments, the SEC clarified in January that extracted performance indeed does include performance of single investments. So now basically translate to a blanket prohibition on gross performance results without presenting net performance alongside those results, even for individual investments. The rule and the guidance don't prescribe specific methodologies for presenting this performance on an investment by investment basis. So it's created an issue for managers struggling to figure out how to allocate the fees and expenses on an investment by investment basis when that's not how they're in fact allocated or charged, and can obscure the results and the reality of the performance of particular investments. For hedge funds, it's a little bit more straightforward because it's based on NAV, but in the PE space, investment managers are really facing a lot of difficulty given the structure of their funds, including how and when carry is allocated. And that's led to a number of managers just electing to sidestep the issue and not include any extracted performance in their marketing materials. The next subset of performance requirements relate to hypothetical performance, which the SEC has always been focused on, specifically as it relates to clearly disclosing that performance is hypothetical and not actual, and disclosing the assumptions made in calculating the performance and the risks and limitations in using the performance. And all that generally still applies, but there are two notable changes in the marketing rule. One is that registered investment advisors now have to adopt and implement policies to ensure that the performance is relevant to the intended audience, given their financial knowledge and sophistication. So the rule doesn't limit presentation of hypothetical performance to specific audiences, but you need to show that audiences are likely to understand the risks. So a lot of firms now have two sets of marketing materials, one for accredited investors and one for institutional, perhaps more sophisticated investors. The other new requirement is that, or the other new change is that hypothetical now specifically includes target and projected performance, which had traditionally not been considered hypothetical performance as it's aspirational in nature versus other hypothetical performance, which is back-tested or simulated. So that's something to keep in mind as it is a change and could be overlooked by managers. The next category of performance or requirements relate to performance of specific investments or cherry picking. Under the old rule, there was an outright prohibition under the marketing rule of including past profitable recommendations, subject to certain limited no action letter guidance when it could be provided, but it was very specific and very limited. Now, managers can include performance of specific investment advice, but it has to be presented in a fair and balanced manner. And you have to provide or offer to provide results of the entire portfolio, not necessarily all investments in the portfolio, but the portfolio as a whole. So even though there was that, or there is that change within the rule, there's really no significant practical differences, because in complying with the fair and balanced approach, we expect managers will take into account prior no action letter guidance. So for example, if you're including your top 5 best performers, you would consider also including your bottom 5 worst performers. So not really much has changed in that regard. The next category of performance is related portfolio performance. The marketing rule now requires that if you're going to include performance of related portfolios within your advertising materials, all related portfolios have to be included, unless by virtue of excluding one portfolio, the results advertised are not materially higher. And the definition of related portfolio is sort of as expected. It's a portfolio managed by the investment manager with similar investment policies, objectives, strategies as the one being advertised. One thing to keep in mind is that this includes managed accounts. So it's not just other private fund portfolios, it's also portfolios of managed accounts that have the same investment policies and objectives. And then the last requirements of performance under the new marketing rule that I'll discuss is the portability of performance from prior advisors. The marketing rule really just codifies guidance from prior no action letters. So there's not a tremendous amount that's new here either. Basically, the performance needs to be relevant and the background disclosed. So some of the requirements include those who were primarily responsible for achieving the results at the prior advisor have to be the ones who are managing the accounts at the current advisor. So if there was a committee managing the portfolio at a prior advisor, unless a majority, or what they call a substantial identity of the committee, has moved over to the current advisor, you can't use that performance. There has to be clear and prominent disclosure. So you basically have to give the background that this performance was achieved at a prior advisor and who was responsible, and basically kind of give the background story. And then a really important requirement is that you need supporting records for this performance. So this often becomes a negotiation point when someone is leaving one firm and going to another firm. You want to make sure, the person wants to make sure that they have access to the records and really can get copies of the supporting records, and that they're entitled to use the track record. So those are sort of a number of ways in which the new marketing rule imposed some new requirements, and then, as I said, codified the guidance under no action letters as it relates to presenting track records.
Beth, it's Joe here.
Sure.
I was just curious, you touched on people creating 2 sets of marketing documents. Could you just, I wasn't sure if I quite understood that. Can you just maybe talk a little bit about what you're seeing in that regard and what people are doing to get to that point?
Sure. So that relates specifically to hypothetical performance. And because you have to have these policies and procedures in place showing that the marketing materials are appropriate for the audience that you're giving them to, that they understand the limitations in hypothetical performance. Some firms have 2 sets of marketing materials. One may not include hypothetical performance at all because maybe they're not provided to sophisticated investors, or they don't think that they should be provided to sophisticated investors, whereas another set maybe is provided to institutional investors and those who would understand the limitations in hypothetical performance, which again now includes target and projected.
Got it. Okay, that makes total sense. Thank you.
Great. And then, separate and apart from the performance requirements, a new requirement which the SEC included in the marketing rule is this requirement to substantiate. They expect an RAA, and it's required that they substantiate all material facts included in marketing materials. So that's always been a good practice to have support for any statements that you made, or if not, to soften the language to we believe, we expect, but now it's an explicit requirement in the rule and a focus of the SEC. So they really expect RAAs to have conducted a gap analysis and to ensure that if they make a material factual claim within the marketing materials, you have the support for it. And if you don't, it's likely to result in a deficiency. So something also to keep in mind.
Great, thank you.
And also, I was covering the marketing rule, which was a beast that was finalized at the towards the end of last year. It also overhauled the regulatory requirements for the use of placement agents to raise capital for private funds managed by registered investment advisors. The rule introduces a new concept of paid testimonials and endorsements that captures the solicitation of investors into private funds by placement agents. Now, traditional private fund placement arrangements involving broker-dealers were not covered by the prior cash solicitation rule utilized by the SEC, but now these arrangements fall within the requirements of the new marketing rule. And the marketing rule imposes 4 conditions on a fund placement arrangement. The first of which is the disclosure requirement. So the advisor must disclose or reasonably believe that the promoter is disclosing at the time of solicitation information about the compensation arrangement and a brief statement of any material conflicts on the part of the promoter. Now, many registered investment advisors may have had this requirement in their placement agreements in the past because it was required under the cash solicitation rule to be provided for the solicitation of managed accounts for that investment advisor. But it wasn't necessarily required for the solicitation of investors into private funds. But because typical private placement arrangements, the agent could go out and solicit for funds or for managed accounts, we would always put it in as a requirement into our placement agreements. But it should be known that now it's a requirement for any solicitation of investors into private funds. At the time of solicitation, the disclosure statement should be provided that briefly explains, whether it's splitting of management fees or performance fees with the placement agent. That arrangement should be briefly described, and also provided the material conflicts on the part of the promoter in the statement. And then you would get the investor to sign that statement, confirming that it's received it. Another big change is now the advisor is required to provide oversight and compliance with respect to its arrangements with placement agents. So an advisor must have a reasonable basis for a belief that the promoter is complying with the requirements of the marketing rule. And the SEC has come out and stated that an advisor cannot rely solely on representations from a promoter in its written agreement that it's complying with the marketing rule. But it actually needs to provide some sort of oversight over the promoter's activities, including, for example, requiring the promoter to only use certain disclosures or scripts provided by the advisor in its discussions with potential investors, the pre-review of testimonials or endorsements to be made by the promoter, and or guidelines or limitations on the contents of those statements. For example, creating a do and don't sheet for the investors, for the placement agent to use in its discussions with investors. In addition, an advisor must have a written agreement with the promoter describing the scope of activities and the terms of compensation to which the placement agent will be entitled. A third change is that the advisor must not compensate quote unquote bad actors and other ineligible persons from solicitation activities. So now solicitation agreements must now have a bad actor rep from the marketer as part of the written agreement. As well as there are certain now new record-keeping requirements on the part of the investment advisor, where the advisor is now required to maintain records of all advertisements that the placement agent disseminates. This means that each communication that a promoter makes to an investor has to be recorded by the advisor. Now, it's been discussion as to what that really means. For an oral advertisement, the investment advisor must maintain either a recording or a copy of any written or recorded materials used by the person in connection with the oral advertisement, including required disclosures and copies of disclosures that are provided separately to the investor. So what is all this? What actions do registered investment advisors should be taking and should have been taking since these rules were finalized at the end of last year? The managers need to have internal policies and procedures addressing how it will oversee the activities of placement agents to ensure that they're complying with the new marketing rule and receiving the necessary records under the record-keeping rule under the marketing rule, including requiring the use of advisor-approved written materials or compliance with, as I said, scripts, restrictions, or guidelines as to what the placement agent can communicate with investors. Agreeing on the form and timing of the disclosures to investors, monitoring and testing the placement agent's compliance, and the method for obtaining the necessary records, including one-on-one communications and the supporting documentation that you'll need to provide in your records. One thing to note, the marketing rule also changed the arrangements for use of non-U.S. placement agents, which now those arrangements are subject to significantly higher burdens under the marketing rule, which in the past there was like limited applicability to non-U.S. agents, and we didn't really worry too much. But now a non-U.S. placement agent soliciting even for a non-U.S. fund, but a non-U.S. fund that's either a feeder fund of a U.S. fund or it's a non-U.S. fund that it's managed by a U.S. Registered investment advisor, are still subject to the requirements of the marketing rule and have to comply with the requirements just discussed. And lastly, to touch on the one further complication of the marketing rule is many managers, whether it's private equity, hedge funds that have been around for a while, typically set up data rooms in their offices or online, but typically just discussing in data rooms and in the office space with historical material as well as current materials provided. And given what Beth had just described, the host of new changes, most of these historical documents are not going to be in compliance with all these requirements under the marketing rule. And so how to handle the investor need to look back at older materials as well as the new materials. And the consensus is now that managers should set up a walled-off data room with historical information put in a separate room, separate and apart from the new compliant materials, and taking the position that historical data does not meet the definition of marketing under the rule, and therefore you do not have to go back and make sure all your old marketing decks and whatnot comply with all these new requirements.
Michelle, I had a quick question. Are you seeing people, you touched on briefly something regarding like visual recordings and that type of situation. Are you seeing people employ that at all? That was an interesting thing to hear. Right. I'm curious what you're seeing.
I personally have not. I know though that there's technology and clients are discussing with their technology provider the use of technology to record those communications in order to capture what's required under the record-keeping requirements. But I have not seen clients. I think for the most part, most clients are just relying on documented, like sending along. The promoter just passes along the investment advisor's marketing deck, private PPM and other marketing materials, and provided by the investment advisor. But in situations where there are, meetings, oral discussions, that is something to think about how to capture the content of that meeting.
Okay, thank you.
Sure. Now we are going to switch gears a little bit and get into the recent, at least the last few years, focus of the SEC on off-channel communications. and give some background on the recent aggressive SEC enforcement actions in the area of how investment firms monitor and maintain records of off-channel communications. Now, just to give a brief overview, off-channel electronic communications are those that involve means that are not sanctioned by a firm. So these may include use of personal devices, personal email, text messaging, or unapproved messaging app like WhatsApp, and I'm sure there's a host of them that I'm not covering, to conduct business communication. In recent years, the SEC has focused on how firms are handling off-channel communications and warning the industry about the importance of preserving all relevant business records. Now, beginning in 2021, the SEC and the CFTC began taking enforcement actions in this area, and mostly against large broker-dealers. Beginning December 2021, the SEC and the CFTC resolved actions against the broker-dealer arm of JP Morgan for widespread failure by the firm and its employees to maintain and preserve written communications. And in that action, JP Morgan agreed to pay a hefty $125 million penalty in connection with the action. Now, in that case, the SEC found and JP Morgan agreed that its employees often communicated about securities business matters on their personal devices using text messaging, WhatsApp, personal email accounts, and none of these records were preserved by the firm. And importantly, the SEC focused that these practices were done by the high level and senior members of the firm, including the people responsible for implementing and ensuring compliance with the firm's policies and procedures, which were clearly being disregarded. And so that began really the whole host of SEC actions against the large broker-dealers. And in September 2022, the SEC announced that 16 broker-dealers have been fined a total of $1.1 billion in penalties for failing to preserve employee text messages sent on personal devices, among other violations. And recently, this past May, the SEC charged HSBC and Scotia Capital for widespread and longstanding failures by the firm's employees to maintain and preserve electronic communications. So shortly after that announcement in September 2022, the SEC kicked off an investment advisor sweep, submitting document requests to very large private equity and hedge fund managers relating to electronic communications. In this sweep, they requested a large amount of documentation from these advisors, including policies and procedures around electronic communications, devices and platforms, monitoring, testing, use of attestation, employee training, and disciplinary actions for violations. And in February 2023, the SEC released its 2023 exam priorities for investment advisors, which, among other priorities, it highlighted that record-keeping and supervisory programs related to business-related electronic communications are high on this list. And this has become a very hot topic for the SEC, and managers can expect examiners to ask questions about their policies and how the firms are addressing the use of off-channel communications, in their next exam. So, just to get into what the guidance has the SEC provided in this area. From the SEC's perspective, it's no longer sufficient just to have a policy, in a written material prohibiting off-channel communications and obtaining, quarterly or annual attestations from employees that they've been complying with that policy. The SEC now exposed its views on the expectations on the management of off-channel communications in the announcements surrounding those multiple broker-dealer enforcement actions. And in reviewing those actions, we can come up with 5 or 6 policies or focus areas of the SEC where advisors can be expected the focus is going to be in the upcoming exams. So to summarize, from these SEC, what people are calling resolutions, the SEC expects managers to review its supervisory compliance and other policies and procedures surrounding electronic communications, and that these policies should limit what platforms over which business can be conducted, and the manager should be conducting quarterly reviews of devices and maintaining compliance logs of any issues and reviews, and archiving all business-related communications that happen off-channel and recording them to bring them into books and records and take steps to prohibit them in the future. In addition, managers should be monitoring and testing approved communication channels. So looking for and searching for red flags for unauthorized communication. One such way is to do searches in emails and other approved channels for uses of the word text or let's take this offline in emails, and then follow up on any red flags discovered. So managers are going to be expected to increase monitoring for potential off-channel communications and better identify platforms and devices for unauthorized that are being used for unauthorized communications. And also, right now there are a host in recent years of technological solutions for managers can use to monitor and capture communications made off-channel. These solutions allow firms to capture communications on messaging apps and on personal devices, provided that they have the appropriate tracking software installed on those devices. So it's important to speak with a MSP provider or the firm's MSP provider, make sure that you have the latest technology, your firm's using the latest technology to help you comply with this what the expectation is of the SEC in this area. Another area which is found to be important is managers are properly training their employees on their policies and procedures and ensuring that they're adhering to them. So providing annual training and reminders, education on policies and new tech solutions for devices and capturing these communications. So it's standard now for firms to ask individual employees to periodically attest, at least annually, but I believe most managers are doing it quarterly, that they are not engaging in off-platform communications. And it's important to enforce these policies consistently. So if you identify a violation, managers need to have an approach to address the issue. So penalties, disciplinary actions for violations, there should be a policy surrounding that, whether it's monetary penalties, potential job loss for engaging in off-platform communication. And enforce the discipline uniformly across senior and junior staff is very important. So how can managers avoid enforcement for off-channel communications? So advisors should be able to show the SEC when it comes in for an examination that it investigated an issue, it resolved it, and it took remedial action to reduce the risk of enforcement by the SEC. Many firms now are also implementing more rigid two-device policies to distinguish between personal and business messages. From my understanding, most of the larger firms are implementing this. So no longer just having one bring your own device, BYOD, bring your own device where everything is commingled. But if you are allowing employees to use their own devices to conduct business communications, the firm should be clearly designating channels allowed for electronic communications for business communications and logging the traffic into an archive system. And the firms may be able to allow employees to use their personal devices, provided that the devices have the appropriate tracking software installed. It's important also, most important, to get your senior management to buy into the necessary changes. As I said, in the JP Morgan settlement, the SEC was very focused on the very senior executives engaging in these violations and the tone and set at the top of the company that they take it, whether they take it seriously or not. So I don't know if that.
Michelle?
Yeah.
It's
sure.
Joe. I'm just curious what your view is, or your opinion is on what the sort of proper punishment range is. How strict or how lenient
right.
is dangerous, meaning, someone does one violation, I could understand the sort of documentation and the slap and maybe
right.
moving
right.
on.
Exactly.
What do you think are appropriate levels of punishment when you get to that second and third violation?
Right. So I believe firms are possibly utilizing monetary penalties for maybe the first infringement or the second infringement but I think at some point job loss needs to be discussed given what's at stake. I mean, you're talking about very large penalties that were imposed on these on the broker dealers, and we'll see in the next year or so what comes down on the managers. But I think that there's probably some kind of sliding scale that people are starting to use for infringement.
Except, yeah, I like the sliding
Like
scale.
other compliance policy violations, you know, if there's one violation, it's one type of penalty, but if it's a pattern of behavior, then you have to consider other courses of action.
Right. Great. So I'm going to briefly touch on next a change that happened that came towards the end of last year as well for 13F filers. These are mostly large, investment hedge fund managers who routinely file 13F. Now, in addition to having to file a 13F, there's this new form that needs to be filed annually. That in the past had only been required to be filed by registered funds to document their proxy voting record. Now, effective July 1, 2024, institutional investment managers that file Form 13F must now make a public filing on Form NPX to report their so-called, quote, say-on-pay proxy voting record, which are shareholder advisory votes on executive compensation matters, including compensation paid to public company executives, the frequency of executive compensation approval votes, and any so-called golden parachute arrangements in connection with a merger or acquisition. Now, the new requirement for managers applies when the institutional investment manager has exercised voting power. The voting information report includes identification of each voting matter and a brief description of the matter and number of shares voted. Managers will also have to report on NPX the number of shares of an issuer it loaned out but did not recall prior to a voting record date. So all these things, so for the first filing, which is due by August 31, 2024, it will cover the period from July 1, 2023 through June 30, 2024. So it's important for managers to track, starting this July, their say-on-pay votes, proxy votes, and any shares that they've lent out at the time of any say-on-pay votes to allow for accurate reporting next year of the required information on Form NPX. And even if managers do not vote on any reportable matter during the applicable period, they're still required to file. And the file obligation is limited to just a notice report indicating that no votes were made or cast. And if a manager has a disclosed policy of not voting proxies and in fact did not vote during the reporting period, it may indicate this also on the Form NPX without providing additional information about each voting matter. And just in addition, managers should review also their current written policies and procedures with respect to proxy voting and securities lending and recall practices to ensure that they're consistent with the manner in which they're going to present those votes on the new form. So this is going to entail much more record keeping requirements for managers on these types of matters. Just something to keep in mind as the period did start this month, July 1. So I think now Beth is going to start off on some new SEC proposals. I know we're getting close to time, but we're going to try to touch on, there's been a whole host of significant proposals that the SEC has been over the last couple of years that are expected to be finalized in the next, whether it be in the fall or shortly. And Beth's going to start off.
Sure. So the first set of proposals are the private fund advisor reforms. These were proposed in February 2022 with 2 comment periods, and the SEC is now indicating a goal for adoption in October 2023. Originally, they said April, but they didn't meet that goal. So there are basically 2 sets of requirements in the reforms. The first set of requirements apply only to registered investment advisors to private funds. And those are that the advisors have to provide quarterly statements to investors in the fund detailing certain information about the private fund, performance, fees, expenses within 45 days of the calendar quarter end. Hopefully that's not tremendous burden, given that many managers already have the information readily available and best practice is generally to keep your investors updated. The second requirement that applies, again, only to registered investment advisors of private funds are that they obtain an annual audit for each private fund. A lot of investment managers already do this because they're deemed to have custody under the custody rule. So this is a way to be deemed to comply with a number of provisions of the custody rule. So a lot of them already do it, but it's going to be a requirement for registered investment advisors. And separately, the rule prohibits all private fund advisors, including those who aren't registered, from engaging in certain practices, which is a bit of a change from the SEC's history, where they've been more focused on disclosure. As long as you disclose certain practices and the related risks and conflicts, they're permissible. But now the proposed rule contains a number of outright prohibitions. So the first, and again, this is for all private fund advisors. The first relates to charging certain fees and expenses to a private fund, including regulatory and compliance fees and expenses of the advisor, those incurred in connection with an examination of the advisor by governmental or regulatory authorities, and those compliance expenses that the advisor incurs in connection with, for example, preparing Form ADV. This is a big change for a number of managers who often charge those fees, again, with appropriate disclosure. And the SEC, in its release, did invite comments whether it should make an exception for those situations with disclosure. But until we see what they adopt, private fund advisors should take the opportunity to review what fees and expenses they currently allocate to funds, as well as the related disclosures to investors. The second set of prohibitions as it relates to expenses is there can be no non-pro rata allocation of fees and expenses related to an investment or potential investment when an investment manager has multiple private funds and other clients investing in the same portfolio investment. This includes broken deal expenses, so it creates certain challenges for, in particular in the PE space, when you may have a co-investment vehicle or a number of co-investment vehicles that have proposed to invest in a deal, and then when it falls through, there's a question in terms of who's going to assume those costs. So we anticipate in those situations, a number of managers will probably elect to assume the co-investment vehicle's pro rata portion of those expenses. The second prohibition is a private fund advisor cannot seek indemnification or limit its liability by the private fund or with respect to the private fund for a breach of fiduciary duty, willful misfeasance, bad faith, and importantly, negligence. This could have significant repercussions throughout the industry because gross negligence, for example, tends to be a standard in investment management agreements. So we'll see if that's adopted as proposed. The third prohibition is that a private fund advisor can't borrow money from a private fund client or receive an extension of credit. It doesn't prohibit a private fund advisor for making a loan to a private fund, but it prohibits borrowing money. And then the last sort of set of prohibitions relates to preferential treatment in side letters. The SEC in the proposed rule would prohibit private fund advisors from providing to select investors preferential treatment regarding redemptions or information about portfolio holdings or exposure. The SEC views these terms as having a potential of having a material negative effect on other investors. So that would be outright prohibited. And then separately, it would prohibit an advisor from providing any other preferential terms unless those terms are disclosed to investors in the offering documents. So again, that would have significant impact on a fund's operation, including potentially impacting capital raising because seed investors often have access to enhanced information. So that's the private fund advisor reform. The second significant proposal is the safeguarding rule, which is getting a lot of attention, and replaces the current custody rule. So it was proposed in February, and again, the SEC indicated a goal for adoption in October. So we'll see what happens there. But the proposal expands the custody rule in two important ways. The first way is that it includes a broader scope of client assets that are subject to the rule. While the current custody rule applies to client funds and securities over which the advisor has custody, the safeguarding rule would expand the definition of assets subject to the rule to include funds, securities, or other positions held in a client account. This is intended to encompass new investments as strategies evolve and would include, for example, crypto assets, real estate, physical commodities, financial contracts, so instruments that wouldn't have necessarily fit within funds and securities under the current rule. The second way in which the proposal expands the scope of the current custody rule is that it broadens the scope of activities subject to the rule. And it would include situations in which a registered investment advisor has discretionary trading authority. In those situations, the registered investment advisor would be deemed to have custody. That's currently an exception under the custody rule for authorized trading. So again, this would impact a lot of, in particular, managed account arrangements, where a registered investment advisor may not otherwise have custody, but certainly have discretionary trading authority, where it was an exclusion from the advisor being deemed to have custody. So that's a big change. The safeguarding rule would also proposes certain changes to the qualified custodian arrangements. The SEC has always and continues to view qualified custodians as key gatekeepers. So they are imposing certain new requirements as it relates to the arrangements with the qualified custodian. The first, who maintains the assets of the client. The first is that the proposal mandates a written agreement between the registered investment advisor and the qualified custodian, under which the qualified custodian agrees to maintain possession of the assets over which the advisor has custody. And that agreement itself has to have certain contractual provisions and protections. If adopted, the current custody agreements of most private funds would need to be amended or novated to add the registered investment advisor as a party, which the SEC would be a departure from industry practice, which it certainly would. And it could also be costly and time sensitive to negotiate with qualified custodians, and unclear if they would accept a lot of these terms that a registered investment advisor now has to include in the agreement, or perhaps that the modifications would result in higher fees. So see what happens there. Another requirement is that there's a change to the qualified custodian definition, which relates to banks and agencies. They can still qualify as qualified custodians, but now they have to maintain client assets in a bankruptcy remote segregated account that's clearly identifiable as the client asset to protect them from, and not bank assets, to protect them from creditors of the bank in the event of an insolvency or failure. I think we're getting short of time, so I'm going to skip the rest of the.
Yeah, I'm getting some feedback on your side, Beth. I'm not sure, but I had a quick question. Early on when you were talking about some of the changes, something that caught my ear was just, am I understanding it correctly that something, let's just say ACA compliance, that does outsource compliance payments, while I think most people, in quotes, would source that to a management company, some people source part or all of that to the underlying funds as part of, their expense allocations. They're specifically saying there that that's something that they don't want allocated to the fund as a sort of bright line test. No, that has to be management company.
Yeah, in the proposal for the private fund advisor reforms, they said that fund-related compliance expenses can be charged, but not any manager compliance expenses. So ACA compliance expenses are often relate solely to the investment manager, and it's a little difficult to distinguish between those that relate to the fund and the manager. So
yeah, exactly. I guess maybe if you're monitoring a position list that the fund can't trade in the system, you could argue that's maybe for the fund itself. But then you're into some situation where you're allocating or apportioning based on some policy where you say 15% of it is allocable to the fund, 80, and then you get into this sort of soft analysis where they might argue with you. But okay, that's good. I just wanted to check I understood it.
yeah.
That's helpful. I just wanted to do a check-in for everybody. I know we try and keep everybody on the schedule. If anybody has any other questions they want to submit in while we have everybody on, you can use the questions feature. We'll also, I think we agreed up front, we'll also send out to everybody who attended contacts and a recording of the presentation. So if you want to re-listen to it or clarify anything you heard, we can always do that. Just looking, all right, I don't see any other questions coming in. I wasn't sure, I didn't mean to cut you off either if you have more things you wanted to cover, but
I was just gonna and with just to keep in mind that also the proposal, which might be a biggie coming down the pike this fall, is the new cybersecurity rules and cyber reporting, in more particular for registered investment advisors, that were proposed in February 2022. The new rules are expected to become final potentially by October with minimal changes. And just high level, the rules would require advisors and funds to adopt written policies and procedures to address cybersecurity risk of the firm, and covering a whole host of topics. But most importantly, advisors would be required to promptly report to the SEC any significant advisor cybersecurity incident or fund cybersecurity incident in no event more than 48 hours after having a reasonable basis to conclude the incident has occurred. Now it's expected that hopefully they'll give you a little more time, potentially 72 hours to report breaches, which would be in line with the new reporting requirements under Form PF. But this is still, a very short window. It's not business days, it's hours. So if you have an incident on Friday, you'll be reporting over the weekend. And these, these incidents
I assume they mean from the time that you find out about it, which might be months after it happened.
Right. After you have, after you've have the reasonable basis, after you've seen the incident, right. So it would be after you find out exactly. And these incidents will be reported to the SEC on a new form, ADVC, which will be required to be publicly disclosed. In addition, these proposed rules will require advisors to disclose to investors on ADV Part 2 any cyber incidences that occur within 2 years of the filing, and you're required to update this disclosure after any material incident. And there's a host of record-keeping requirements in addition as well. And so far, there hasn't been any hard guidance yet from the SEC regarding these reviews and reporting requirements. But management, can be expect that this area to be covered in an exam. And to summarize, if managers haven't started already, you should begin to assess your cybersecurity risks, develop policies and procedures in the area, test the policies, and do annual reviews of the programs, and really speak with your MSP provider, make sure that you're up to date with your IT and cyber side to keep up with the latest technology, because this is an area that the SEC is expecting to focus on, as well as everything else we talked about today. But that's it in a nutshell.
That's great. That's you might have ended with the scariest one of all. So that's
I think that's why I wanted to get it in. Yeah, exactly.
appreciate it. Okay, great. So a reminder to the group, I will handle CPE certificates for everybody and follow up with you. So don't be worried. We'll make that happen for everybody as I get the system back up and running for CPA. And I just wanted to thank you guys for a terrific webinar. It was, you know, the perfect combination of insightful and scary, which it should be. You know, as we all keep on our toes on this end, and I hope we could do another one maybe later in the year. Talk about how some of this has progressed and what else they've dreamt up on the other side to make us all continue to have plenty to do. But this is very helpful. And I remind everybody, including Beth and Michelle, to join us in October for our annual event. And if you haven't registered, register. I know I'm harping on it, but I want to make sure everybody gets out and we can see everybody. So thanks again for the time, and we will speak soon.
Thank you.
Take
Bye.
care.
Bye-bye.